Hello, this is R.J. Deacon, reading the opinion syllabus in the Supreme Court of the United States in Lozeman versus City of Riviera Beach, Florida. Certiorari to the United States Court of Appeals for the 11th Circuit. Argued February 27th, 2018. Decided June 18th, 2018. After Petitioner Lozeman towed his floating home into a slip in a marina owned by the city of Riviera Beach, he became an outspoken critic of the city's plan to use its eminent domain power to seize waterfront homes for private development, and often made critical comments about officials during the public comment period of city council meetings. He also filed a lawsuit alleging that the city council's approval of an agreement with developers violated Florida's open meetings laws. In June 2006, the council held a closed-door session, in part to discuss Lozeman's lawsuit. He alleges that the meeting's transcript shows that the council members devised an official plan to intimidate him, and that many of his subsequent disputes with the city's officials and employees were part of the city's retaliation plan. 5 months after the closed-door meeting, the council held a public meeting. During the public comment session, Lozeman began to speak about the arrests of officials from other jurisdictions. When he refused a council member's request to stop making his remarks, the council member told the police officer in attendance to carry him out. The officer handcuffed Lozeman and ushered him out of the meeting. The city contends that he was arrested for violating the city council's rules of procedure by discussing issues unrelated to the city and then refusing to leave the podium. Lozeman claims that his arrest was to retaliate for his lawsuit and his prior public criticisms of city officials. The state's attorney determined that there was probable cause for his arrest, but decided to dismiss the charges. Lozeman then filed suit under 42 U.S.C. 1983, alleging a number of incidents that, under his theory, showed the city's purpose was to harass him, including by initiating an admiralty lawsuit against his floating home. See Lozeman versus Riviera Beach. The jury returned a verdict for the city on all of the claims. The district court instructed the jury that, for Lozeman to prevail on his claim of a retaliatory arrest at the city council meeting, he had to prove that the arresting officer was motivated by impermissible animus against Lozeman's protected speech, and that the officer lacked probable cause to make the arrest. The 11th Circuit affirmed, concluding that any error the district court made when it instructed the jury to consider the officer's retaliatory animus was harmless, because the jury necessarily determined that the arrest was supported by probable cause when it found for the city on Lozeman's other claims. The existence of probable cause, the court ruled, defeated a First Amendment claim for retaliatory arrest. The Supreme Court held, vacated, and remanded. The existence of probable cause does not bar Lozeman's First Amendment retaliation claim under the circumstances of this case. The issue here is narrow. Lozeman concedes that there was probable cause for his arrest. Nonetheless, he claims the arrest violated the First Amendment because it was ordered in retaliation for his earlier protected speech, his open meetings lawsuit, and his prior public criticisms of city officials. In a 1983 case, a city or other local government entity cannot be subject to liability unless the harm was caused in the implementation of official municipal policy. See Monell versus New York City Department of Social Services. The court assumes that Lozeman's arrest was taken pursuant to an official city policy. The two major precedents bear on this issue whether the conceded existence of probable cause for the arrest bars recovery, regardless of any intent or purpose to retaliate for past speech. Lozeman argues that the controlling rule is found in Mount Healthy City Board of Education versus Doyle, a civil case in which the City Board of Education decided not to rehire an untenured teacher after a series of incidents, including a telephone call to a local radio station. The phone call was protected speech, but the court held there was no liability unless the alleged constitutional violation was a but-for cause of the employment termination. The city counters that the applicable precedent is Hartman versus Moore, where the court held that the plaintiff alleging a retaliatory prosecution must show the absence of probable cause for the underlying criminal charge. If there was probable cause, the case ends. If the plaintiff proves absence of probable cause, then the Mount Healthy test governs. Whether Hartman or Mount Healthy governs here is determination that must await a different case. For Lozeman's claim is far afield from the typical retaliatory arrest claim. The difficulties that might arise if Mount Healthy is applied to the mine run of arrests made by police officers are not present here. Lozeman alleges that the city itself retaliated against him, pursuant to an official municipal policy of intimidation. See Monell. The fact that he must prove the existence and enforcement of an official policy motivated by retaliation separates his claim from the typical retaliatory arrest claim. An official retaliatory policy can be long-term and pervasive, unlike an ad hoc, on-the-spot decision by an individual officer, and it can be difficult to dislodge. A citizen can seek to have the individual officer disciplined or removed from service, but there may be little practical recourse when the government itself orchestrates the retaliation. Lozeman's allegations, if proved, also alleviate the problems that the city says will result from applying Mount Healthy in retaliatory arrest cases. For it is unlikely that the connection between the alleged animus and the injury in a case like this will be weakened by an official's legitimate consideration of speech. See Rochelle versus Howards. And there is little risk of a flood of retaliatory arrest suits against high-level policymakers, because Lozeman alleges that the city deprived him of the right to petition, one of the most precious of the liberties safeguarded by the Bill of Rights. See B.E.N.K. Construction Corporation versus NLRB. His speech is high in the hierarchy of First Amendment values. On these facts, Mount Healthy proves the correct standard for assessing a retaliatory arrest claim. On remand, the 11th Circuit may consider any arguments in support of the district court's judgment that have been preserved by the city, including whether a reasonable juror could find that the city formed a retaliatory policy to intimidate Lozeman during its closed-door session, whether a reasonable juror could find that the arrest constituted an official act by the city, and whether, under Mount Healthy, the city has proved that it would have arrested Lozeman regardless of any retaliatory animus. The decision is vacated and remanded. Justice Kennedy delivered the opinion of the court, in which Chief Justice Roberts and Justices Ginsburg, Breyer, Alito, Sotomayor, Kagan, and Gorsuch joined. Justice Thomas filed a dissenting opinion. Thank you for listening, and if you would like to join in a discussion on this or any of the other cases that were decided, please find us on our Facebook group at facebook.com/SCOTUSSLIP. Thank you.